Good morning, everyone. Thanks so much for joining us. We're just going to give it a few more minutes, let a few more people hop on, and we'll be back with you in just a few moments. Okay, I think we're ready to get started. I'm going to turn it over to Chuck in just a few minutes for a quick introduction. Just wanted to let you guys know, I know most of you have been with us before doing this, but if you have any questions, go to the right-hand side of your screen and enter the questions, and we will address them at the end of Greg's presentation. And with that, I'll turn it over to Chuck, and here we go.
Good morning, everyone. We're fortunate again to have Greg Ossi join us. Greg's a partner at Faegre Drinker, which is a major DC law firm, a top 50 firm in the U.S. with over 1,300 lawyers. He's a graduate of Washington Lee. He's got a master's from UVA and graduated from Catholic University Law School. And he's not only an attorney, but he's also a CPA, which is a rare commodity. So an unusual skill set. We had Greg speak to our community, I think in July, mid-July. He was very helpful in addressing some of the issues for immunization in the construction industry. It was well received. A lot of, we got very good feedback from that. So we wanted to have Greg talk to the MTA community about EO 13706, which has been in existence for a few years now. It's evolving, and so kind of give our community a where we've been, where we are, and where we could possibly be heading. And then after he's done with the presentation, I've asked Greg to briefly, insofar as he can, address that very special press conference that was held at the White House late Thursday afternoon that shocked a lot of us. So Greg, without further ado, thanks so much for your help.
Thanks, Chuck, and good morning, everyone. Thanks for joining, and hopefully this will be helpful. As Chuck mentioned, this particular executive order has been around for a while. Some people thought it went away during Trump. It was passed. It was created in 2015 under President Obama, and then Vice President Biden. Now we have current that former Vice President, now President Biden, is in the White House. Some people thought because Trump did do away with a number of executive orders that were given out during the Obama administration, that this would be one of them. Unfortunately, it is not. It has been present since it was enacted, or rather executed into law back in 2015. So today I want to cover a couple things about the law. We'll talk about the requirement to provide paid sick leave for federal contractors. So we're going to go over three main areas of the subject: coverage of the law, how it applies to collectively bargained individuals and employers, and then the actual amount of leave that's required and how you track it, and some of the more interesting parts of the law with regard to administrating it, or the administrative application of the law. At any point in time, if you have questions, please let me know, or you can wait till the end after we've done, and you can put your questions either in the chat or let Chuck know, and we can address them. So again, this executive order came into being in 2015, but it was not actually enforced until for government contracts. So this is part of the government contracting law. It was not into effect except for contracts coming into being after January 1st, 2017, and that means any contracts not only that were new but that were renewed or extended or were similar to being created anew after January 1st, 2017. So likely now all of your government contracts, if you're working on any, are covered by this executive order. And what I mean by that is, what do you mean by federal contractor, Greg? Well, there's a number of different categories. The two most important for us today really is the Davis-Bacon Act and the Service Contract Act, or SCA. So who is covered by this executive order? Well, it's all employees that are covered by Davis-Bacon or Service Contract Act, including those that might meet the overtime exemption for blue-collar workers. Also included in this is so anyone working in or on the federal government contract. And we're going to touch base on that very important concept later on in the presentation when we talk about the new executive orders by Biden and COVID-19 vaccine mandates. But in general, this is an expansion of who is normally covered under these acts. So normally under Davis-Bacon or under the Service Contract Act, you're really covering those employees who are not exempt from the Fair Labor Standards Act, or FLSA. So typically your office workers potentially who are not performing work under the contract, or your executives who are not performing work under the contract, or your secretaries, for example, who are not performing work under the contract, are not covered by the Davis-Bacon or Service Contract. They're not performing work that's required by the contract. If you're fixing a boiler at a federal government institution, or if you are doing repair work or maintenance work on a building, etc., typically those are the employees that you're going to be covered by Davis-Bacon or Service Contract Act. This law is more expansive, so it touches not only on those who perform work necessary to the government contract, i.e., that forms the why the government contracted with you in the first place to get your construction services, but also those that work under the contract are covered as well, except if they spend less than 20% of the hours work every week performing work that is, or rather, if less than 20% of their time is spent working on work that is directly connected to that Davis-Bacon or Service Contract Act contract, that federal contract. So again, just to be clear, this law can potentially cover, for example, supervisors. If you have a supervisor that works, more than 20% of his or her time supervising employees that are working under a federal government contract, then that supervisor would have to be covered under this paid sick leave coverage. And again, this is going to become even more important as we talk about these new Biden executive orders, because it's more expansive coverage required. What about collective bargaining? Okay, so a couple things here. If you're, and this is why it might be coming up again, because it wasn't until recently that if you had a CBA that was ratified prior to September 30th, 2016, you actually did not have to follow the rule. You just had to follow what was in your CBA with regard to sick leave until either the earlier of your CBA expired or January 1st, 2020. So since January 1st, 2020 has passed, that's in most contracts, or all contracts should have this requirement in there, or if they don't, you have to follow the law, regardless of what's actually in your CBA. So again, post 2016 ratified CBA should have to match or exceed this rule. One of the other things about a CBA that you can have is, as you understand, you have a lot of fringe benefits that are required under your CBA. In addition to pension and healthcare, you have annuity funds, you have training funds. A CBA, it is allowed under this law to have you could have for example, a health plan that also provides sick leave, or any other fund, or a special fund, a vacation fund that also provides sick leave. And as long as that sick leave was same coverage as required by the law, it'd be sufficient enough if you just contributed into that plan, that multi-employer plan that provided coverage for those employees that would be eligible for this paid sick leave, i.e. those that are working on a federal government contract. So what is actually required by the law? So it can be done in two ways, but the main body of the law says for every 30 hours of work on or in connection with the contract, you must accrue 1 hour of leave. And again, on or in connection with the contract covers not only those employees, working for the specific performance under the contract, whether it be actually pipe fitting or doing, for example, if you're a service contract, could be just cleaning up, but also those working in connection with. So that if you had a security guard that you had employed that was guarding a construction site, that would be in connection with the contract, and they would also be entitled to this accrual of sick leave, again, if they're working at least 20% of their time on this federal government contract. So again, it's 1 hour, the accrual is 1 hour of leave for every 30 hours worked, or you can front load it. You can provide the employees at the beginning of every year with at least 56 hours of paid sick leave to be used during the year. For those of you who are already familiar with the Davis-Bacon or Service Contract Act rules, you have to track time, and that's no different for making sure that you're complying with this rule. If you're not tracking time, then you need to keep time with this rule, or there is an exception that allows for reasonable estimates to be made for those who are not already tracking their time. But since the likelihood is you're already tracking time, you won't need to add any additional systems. But if you're adding it, for example, if you don't track the time of those, for example, a payroll clerk that's simply paying at least 20% of his or her time for in connection with the federal government contract, then you would have to track their time, or at least provide a reasonable estimate of what you think, how much time they spend on the federal government contract in order to accrue the appropriate amount of sick leave. There's a notification requirement, so that, and most people do this through their payroll, through their pay stub, just putting it in there, how many hours they've accrued, unless they're front loaded it. In which case they just tell them how much they have left available. The notification period, or rather the notification just needs to be in writing somehow, so it doesn't have to be on the pay stub. But one of the easiest ways to do it, obviously, is the pay stub. But you need to notify employees at the end of each pay period. And the rule actually is at least a month or earlier if it's a pay period, since most people pay are required to be paid at least monthly, if not more frequently than that. I just say it's just easiest to know that every pay period they need to be notified of the amount of paid sick leave that they have available. There is a provision that allows for carryover of sick leave. Up to 56 hours each year can be carried. So if you don't use the 56 hours, you can carry it over. But importantly, the law limits an employee to only having 56 hours at any time. So if you don't front load, for example, an employee has accrued 56 hours in year one, during year two, that employee and doesn't use any, that employee will have 56 hours available to use, and you may stop accruing any additional leave until such time as that employee actually starts using it. So if that employee in year two who has 56 hours of leave accrued takes 16 hours of leave, then in the middle of the year and continues to work on a federal government contract, then they could accrue up to 16 more hours, and that can continue, and so on and so forth. And so, for example, if you front load and someone uses the sick leave, they don't accrue any additional amount. It's just 56 hours per year. It is possible to use more than 56 hours a year if under this system, but an employee may never have more than 56 hours available at any time. If you do not have to pay out, maybe I'll take this a little in reverse order that's on the slide. You don't have to pay out if an employee terminates their employment with you during the year. You don't have to pay out any accrued sick leave. You can if you want, and that has an impact on reinstatement, but you don't have to. Unless your CBA requires it, you don't have to pay out for, the federal government law does not require you to pay or cash out any unused paid sick leave under this executive order. However, if you do reinstate an employee after a job loss within 12 months of that job loss, they get to have their accrued sick leave back, again, unless they've been paid out. So if someone has 56 hours of accrued leave, they're terminated in the middle of year 1. In year 2, they're hired in the first quarter. You have to reinstate that 56 hours of paid leave. Now, if they only had 2 hours of accrued leave, you'd only have to reinstate the 2 hours. So what can an employee use this paid sick leave for? Basically, almost anything dealing with mental health or physical health, and also domestic violence and assault and things surrounding that. What does that mean? All right, so we'll take this in 2 categories. First, it covers both the employee's own physical and mental illness, as well as those related for caring for others, basically. So an employee can use it for his or her own illness, could be physical or mental illness, could be for an injury, a medical condition, could be used to go see the doctor, go see a chiropractor, go see a therapist, etc. Or it could be used, if they're the victim of sexual assault or of any domestic violence or stalking, it can be used for that. And not only does it, in that last category, not only are we talking about medical or mental illness, so physical or mental illness, but also time necessary to go to the court, to talk to a detective, for example. Anything related to those categories of domestic violence, sexual assault, or stalking is time that can be used under paid sick leave, even though technically you and I might not think of it as, quote, sick leave. So the same thing can be applied in terms of taking time, an employee taking time to use this paid sick leave to care for others. So, and that category is pretty broad. So it can be that employee's child, parent, spouse, domestic partner, or as the law defines it, a close association with someone who basically is like a family member. How that's determined, it's very broad. So it's a judgment call. It's not easy to make, and there hasn't been a lot of cases on this at all to be able to give you further delineation of when that might come into being. So again, it covers the same activities as employees. So what does an employee need to do to invoke this paid sick leave? They just need to make a request. Either doesn't have to be in writing, can be in writing, but just as long as they make requests, say I need to use my paid sick leave. I've got a doctor's appointment and I want to use it for that. They need to give you 7 days advance notice, unless that's not reasonable, and then the executive order switches and says, well, as reasonable practical under the circumstances. So if someone is injured on the job and they need to take the next day off to see a doctor, even though it's not 7 days, they can request it, again, as long as it's reasonable notice, reasonable notification, if they can't give you the 7 days. If for any reason you decide that they're not eligible for this request, you have to give them a denial in writing. And furthermore, if they're going to be gone for more than 3 days, before they come back, just like in other laws, like under the ADA, you can ask for a certification of the reason for why they were gone for 3 days. In other words, a doctor's note, etc. The only thing to be careful here is that the law is very cognizant of that last category of coverage for domestic violence, sexual assault, and makes it very clear that someone does not have to provide any certification that would otherwise compromise them or their privacy. But that's really in that specific category. So they would, if they had surgery, for example, they would need to get a doctor or physician's note explaining why they were gone for 3 days. Importantly, and I know this question comes up a lot, is like, well, doesn't this count as a fringe benefit for my purposes of complying with either Davis-Bacon or the Service Contract Act? And unfortunately, the answer is no. This providing paid sick leave is not considered part of paying fringes under either law. How does this coordinate with other laws? You can run it concurrently with FMLA, which I would recommend. It doesn't have to be, but in other words, if someone is saying I want paid sick leave and they're entitled to family medical leave as well. You can say that this is going to count both as your sick leave and your family medical leave, if it applies as family medical leave. Here it doesn't supplant other state laws, but they can run concurrently as long as, again, that state law is providing at least the minimum amount of time as the federal law. And as everyone knows, we have a Maryland state law that covers this issue. I should be clear, though, that federal law is not preempted. It does not have any requirement of preemption, unlike the Maryland state law, which does have a waiver specifically for construction industry with regard to complying with the paid sick leave law. So you can, and I believe, and I understand you do have in the MCA's contract, you've bargained that with the union, you have the waiver, but that does not apply for federal contracts for this federal paid sick leave. In other words, that waiver does not apply, and you still have to go through all the process that I've just mentioned about providing paid sick leave to those employees who are eligible for it. Furthermore, you can coordinate this with your existing PTO policy. So you can simply have a PTO policy in, for example, in your CBA or under your, in your just general benefits package that provides for 56 hours of paid sick time a year. And as long as you could use that paid sick time for the same things that you can use it for the federal law, then you're good to go. You don't have to do anything else with regard to that. What about some of this? What about coordination with all of the different COVID legislation? Well, remember that we did have some expanded paid sick leave and Family Leave Act that was required under the Family First Coronavirus Response Act, FFACRA, as it was affectionately known as. That is pretty much over, except for those companies that have decided to voluntarily allow for that additional amount of time, it's through the end of this month, and in exchange for tax credits. So you can coordinate leave with that particular leave to count them both at the same time. But that's going to expire pretty soon, and we don't know what will happen if anything to additional extensions of that additional Family Medical Leave Act. So what could be next? Again, like I said, there's a possibility that Congress could come back and expand on those types of leave. We don't know what's happening with these different variants. We've heard a lot about them, the Delta variant, the new variant of the COVID-19. We don't know whether or not that, hopefully this will burn out quickly, but we don't know. We don't know what situation we're going to be faced in, and whether Congress will decide to extend all of these additional paid leave times. Right now, Congress is really stuck on this budget bill. That's been the number has been tossed around as $3.5 trillion. I don't see Congress focusing on this additional paid sick and family leave at this time. I do, in terms of where we are going, I don't see any changes. It came in under Vice President Biden, now President Biden. He's certainly not going to eliminate it. I don't think he's going to expand it. I haven't heard, but it's very possible he could look to expand it as they continue to look at ways to cover people and expand their COVID legislative agenda. Again, there's no indication at present that he would expand it beyond the current amount of time, but you never know. So I'll just leave it at that. We don't think there's going to be any changes to this particular law at present, and it's been around for a while enough, so I think most people who have had to deal with it know how to deal with it. But in case you don't, or you have any questions, let me know, and we'll see if we can't figure them out. I'll take a quick pause right now, see if there's any questions. Otherwise, we'll talk about the next we'll touch base on maybe what you're all more interested in, and that is, what is Biden doing now with this mandatory vaccination and testing?
Hey, Greg, there's no questions so far. If anyone has any questions, feel free to enter them in the question box on the right-hand side. But I think we're good right now, Greg. Do you have any questions?
Okay, great. Bored him to tears. So.
Well, actually, I lied.
One question. This is absolutely not the case. All of our contractors are in full compliance with the executive order and always have been. But let's just say theoretically, someone running a business has been so focused on the other 100 things they have to do that they haven't had a robust plan to address this and to track it. Any advice on what they should do, just like basically starting from scratch?
Can you see?
Sure, Chuck, that's a good question. And what I would say is that without giving any specific, legal advice to anyone, we want to look at your situation, but you want to, I think you do two things. One is you want to come into compliance as quickly as possible. That is on a going forward basis, making sure that you're in compliance with the requirements. And it could be that you've been paying the sick leave, but you haven't been notifying your employees. And it's a tough choice between, definitely want to moving forward. You want to make sure you're in compliance. But what do I need to do retroactively, and how do I be careful about not triggering something that's going to cause a federal investigation and cause me more pain than it's worth, right? So you always want to be careful about that. So what I would suggest is that you want to talk about that with your attorney, but you definitely want to moving forward come up to speed with the law as it's required, and then think about whether or not you need to go back and retroactively apply benefits or provide payments. That's a question of making sure that you're in compliance, but also at the same time not stirring the hornet's nest of something that you may be able to avoid.
Okay, thank you, Greg. Another question: can PTO count if the contractor provides PTO, or does it have to be used for sick to count?
PTO can count, again, as long as it's so I'm sorry I wasn't clear about that. So PTO can count as long as you allow that PTO for everything that the law requires. So if we go back here to what the law requires, as long as your PTO can be used for everything that's on this screen, then it can count for sure. And again, it also has to meet the requirements. Either for example, if you're providing 40 hours of PTO, that's not quite the 56 hours. So 40 of that, so certainly those 40 hours that you provide at the beginning of the year count, but you also then have to accrue that additional 16 hours of federal paid sick leave if the employee earns it. So for example, if you have an employee that's working 100% under a federal government contract all through the year, working 2,000 hours a year, they're going to be entitled to that 56 hours ultimately. If you front load, if you have PTO and you say you can use your PTO at any time, I'm giving you 40 hours, that's perfect. They can use that 40 hours, but after they've worked the amount of hours, and I'm not going to be able to do the math in my head this quickly, but they will have to accrue that additional 16 hours of PTO. So once you've hit that number, then you have to give that additional 16 hours of paid sick leave and on top of the 40 hours of PTO. Hopefully, does that answer your question?
Yeah, that answers the member's question. Yes, thank you. Well said. And it looks like that's the extent of our questions from the MCA members. Maybe we'll take this opportunity to kind of flip to that special press conference we saw last Thursday.
All right, and I'll just start off by saying there's a lot.
I'm sorry, Greg. I'm sorry. Forgive me, Greg. I'm sorry about that. I'm sorry. Proceed.
No, did I screw something?
No, I screwed something up. Forgive me. I was multitasking, which is never a good idea. So you go ahead.
No worries. So just to be clear, this a lot of what Biden said doesn't have detail behind it, and it can be, and it is quite confusing as to what is going to happen. And I think there's some messages of being very stern, but if you go down into the detail, you still see that it's the water is as crystal clear, as a muddy river down in Florida, some ways. So let's talk about what he did do, and then we'll talk about what that might mean. And so he as you said, he has this announcement, calls it the path out of the pandemic, where he's going to combine executive and agency action to try and get the country more vaccinated. And so there are certain specific directives, and I put them here in bold. Among the directives are that, that he's going to require all employers with 100 or more employees are either mandating their vaccine or testing weekly for the coronavirus. He's going to further require that all federal workers be vaccinated, or if you are a federal government contractor, that your employees that are working in or on connection with that federal government contract are vaccinated. As you may know, he's already required a number of healthcare providers to be vaccinated. That will continue, and then he also is saying that if you're going to provide that employers are going to have to provide paid time off for those employees who have not been vaccinated if they want to get vaccinated. So let's digest some of these things and talk about what we know and what we don't know. So again, employers with 100 plus employees. This is a directive to a federal government agency, in this case OSHA, to issue an emergency temporary standard, which they've been working on. And I will tell you right now up front that I am not an OSHA lawyer. I know enough to be dangerous, so let's work together on this. And please forgive me if I totally screw this up, but I'm going to try not to. I've been working with our OSHA lawyers who have been helping me, so hopefully I will get this right. An emergency temporary standard is put into place by OSHA when there is a grave danger to employees. So they have to have a finding that this COVID-19 virus poses a grave danger to employees, and if they make that finding, then they can issue an emergency temporary standard about the COVID-19. It will become effective immediately upon publishing in the Federal Register. I've heard people say that this will be in 30 days, some say 60 days. Again, they've been working on this prior to his announcement. So it should come as no big surprise that OSHA is putting this out there. One thing about an emergency temporary standard is it only lasts for 6 months. After 6 months, it has to be either made permanent through the OSHA rulemaking process, or it simply ceases to exist on the books. Also importantly, unlike the permanent, regular, and rulemaking authority of OSHA and other federal government agencies, there's which provide a notice and comment period. There's no notice and comment period for an emergency temporary standard. So they're simply going to roll it out, and we'll see what. And there won't be any time. There will be time after once they have published it. I think OSHA has said that they will allow for comments on it, but they are going to simply roll it out without seeking comment from the employer community or anybody else, or the labor community, for example. But before we get all excited, let me just say that this is likely going to be litigated. As a strong possibility that this is not under the purview of OSHA, that Congress has not allowed OSHA to have the powers to be able to make this kind of mandatory vaccination and testing requirement. That has yet to be seen. Certainly a number of employer associations and governors of certain states have said, we're going to fight this thing. So I expect that it will show up in the courts very soon. Obviously, as soon as it's published, I expect to see a bunch of lawsuits seeking to enjoin it, to stop. And by enjoining it means it's putting a temporary halt on the government being able to proceed with this. Why is that important? Because there's potential fines under OSHA for violating emergency temporary standards, and those fines can range anywhere from $12,000 to $100,000 per occurrence. So what I'm suggesting now, and we'll talk a little bit more about what detail we know. Again, I wouldn't take any drastic steps. Like I've heard people saying, well, I'm going to get down to, I've got 120 employees. I'm going to figure out how to get down to 99 employees. What I would recommend at this point in time is that you don't need to take such a drastic step. Just wait and see what happens with this, because there will be some time before they actually start enforcing this rule. So again, I give it let's give it a wait and see opportunity. What we know about it is that it will be, the rule when it comes out will be designed to either require mandatory vaccination or weekly testing. Now remember that the federal government agency that oversees employment law, the EEOC, has already said that mandatory employer vaccinations don't break any of the current EEOC laws. Now, just like those EEOC laws, this OSHA law is going to be subject to the other federal laws, which provide for certain Title VII rights and Americans with Disability rights. Including among those rights are religious and medical exemptions. Those will still be maintained, so that if you have a valid religious objection or a medical exemption, like we talked about in July, that whole direct threat process of how you go through that, you as an employee can potentially not be required to get a mandatory vaccination. However, let's talk about weekly testing. Unless you've got some religion, so that applies to the vaccination. For example, you may have a medical condition that prohibits you from being vaccinated because one or more ingredients in the vaccine, etc. However, that same medical condition likely will not prevent you from being weekly tested. So that even though your accommodation may be that you don't have to get the vaccine, you may still have to be tested. But again, this is all a little bit speculation because we haven't actually seen the rule from OSHA, although we can surmise what is going to be in there, and we can surmise what exemptions can be applicable, even if it is a mandatory, if it is that strict to be mandatory vaccination or having a weekly test. What does it mean to have 100 plus employees? Well, it means you have 100 employees. They will need to be counted on a company-wide basis, not just locations. However, more than that, we don't know. We don't know, to what extent you would count an employee as part-time employee, as an actual employee, is there a minimum number of hours, etc. We just don't know that, and that will be left. We'll have a better understanding of that obviously when we see the OSHA rule. So again, not much detail has been provided. Some of you are saying, okay, what about this weekly testing? Who's going to pay for it? Well, again, we've seen that under the Biden law, that if you will have to pay as an employer for those for people who take time to get vaccinated and also recover from any side effects. There are certainly some known side effects. There's certainly enough out there that we know of that has happened, and so employees will need to get paid time off to get vaccinated, and also, should they suffer any side effects, they will have to you will have to pay for their time off as they recover from the side effects of getting that vaccine. We don't know what the federal government will say about, or OSHA will say about who has to pay for weekly testing if someone is unable to get the vaccine, or if you decide as an employer you're either going to require either or. But I will say, it's possibly that your insurer will cover it. Maryland law does have a specific requirement. It's relatively new for essential workers. As you know, construction workers are essential workers. Under Maryland law, the employer has to pay for the cost of the test if it's otherwise not available to the employee, meaning that it is not covered by insurance, or that employee is not able to obtain testing free of charge. There is some good news here, and that is DC has free of charge testing. They have these very easy take-home kits. You do it at home. You put it into a little container. I've done this, for example, right by our public library. They have a giant testing container, so you do it at home. It's a little swab. Put it in a some sort of sealed envelope. You stick it in there. You give them your email address, and then they email you back whether you're positive or not. So there is some free testing that's available, at least in the DC area. Also, we need to take into account that under the Fair Labor Standards Act, FLSA, if you're a non-exempt employee, that is, you get paid overtime, you have to be paid for time spent going through the testing during a work day. This likely also covers testing time during a non-work day. However, that, as any of you who may have had the test, it's very, very quick. I won't say painless, because it depends on how your provider jabs the thing up your nose, but at least it's relatively quick. And that in time also means basically time going to the provider. All right, what about federal contractors? We've heard it said that federal, the Biden rule clearly applies to federal employees. They're going to have to get vaccinated, period. Except, again, the exemptions still apply. The Biden can't overrule the Americans with Disabilities Act or Title VII. So you're entitled to your religious, entitled to at least at the present time, to take that religious accommodation if you have one for not getting the vaccine. Now, I will say that there's certainly a lot of folks out there who say that the religious exemption is not valid, but I'll leave it to courts to decide. Right now, there's certainly nothing that's ruled on it one way or the other. So just keep in mind that when I talk about mandatory vaccinations, there's still the ability for someone to get an exemption under the ADA or as a religious exemption. Now, again, the White House has talked about mandatory vaccinations, but that's actually not what the executive order says. The executive order says that federal contractors are going to have to comply with whatever adequate COVID-19 safeguards are available to the employees. So that leaves it open to a federal task force that's going to look at this. So it could mean that ultimately the executive order, the guidance that will be coming out, will require mandatory vaccinations. Could be something else. Could include testing. Could include mask wearing. We don't know. Obviously, our concern is that it is going to be simply just like the requirements for federal employees, that you do mandate the vaccine, but we don't know. So that hasn't been made clear yet. When will it be made clear? Hopefully by September 24th. The task force is required to explain, give us definitions and explanations of all the protocols of what safeguards they want to put in place. So this guidance is required to be published by September 24th, 2021. Good news is this doesn't apply to current contracts, only to new contracts. So the federal acquisition regulations that govern all government contracts must be, the FAR rules must be amended by next month, October 8th, to require inclusion of this mandate, whatever it is, for all tiers of contractors. This is a flow down. So, whether you're the prime or a sub of a sub, this is going to be a flow down clause that's going to apply to you for any new contract, and those contracts also include extension or a new renewal of an existing contract. So we'll wait and see it to understand what this guidance will require of us. But worst case scenario is it's mandatory vaccinations, but perhaps it could be something else. Could be simply just vaccinations or weekly testing, along with appropriate social distancing and mask wearing. We just don't know what it ultimately will require. But part of the rule says that it will be applicable to anyone working on or in connection with a federal government contract. This is language that mirrors that in the paid sick leave law. So in connection with means that workers who would otherwise not be covered under your federal government contract, so under your Davis-Bacon or your Service Contract Act contract, but who spend time supporting that contract, supporting the workers. So again, like a payroll clerk who provides at least 20% of their time helping, paying, making sure that pay is correctly done for your federal government contracts. Or if you have a security guard at a construction site that is under a federal government contract. All of that is included under someone who spends time in connection with. And again, this could also include, an executive. If an administrative person who was otherwise, a exempt person from the overtime requirements under FLSA, so they're typically not covered by Davis-Bacon or Service Contract Act, but they would be covered either by the paid sick leave or now what we will wait and see on this federal government mandate with regard to the COVID-19 virus and whether or not it's mandatory vaccination or something else. But whatever this guidance will come out, it will apply to those that are working at least 20% of their time in service to that contract. So if all you do is federal government contracts, then ostensibly all of your workforce would have to follow whatever this guidance is. We don't, again, we don't know what the guidance is, but we'll wait and see, and we'll have more for you when it comes out a little bit later this month. Now, how does this affect by collective bargaining requirements? Well, OSHA has stated that it doesn't believe that these emergency temporary standards will impact collective bargaining. But again, as we discussed in July, NLRA law is not trumped by an executive order. So that if you haven't already tackled this, mandatory vaccinations are very likely to be a mandatory subject of bargaining. And all of that, so that includes, the factors that we talked about before. Is there a zipper clause? Do you have a management rights clause? A management rights clause might allow you to unilaterally implement a mandatory vaccine policy. If there's a zipper clause and you're prohibited from making any changes, then you've got to sit down with the union and talk about it. How does a mandatory vaccine rule different from one that's required by the federal government as opposed to just the employer mandate? It is different, and we've seen some case law on that with regard to flu vaccinations. And there, it may very well depend on the makeup of the board and the position of the union. If the union is saying, no, we refuse to go along with this employer mandate, even though you're required by the federal government to provide it, you may have a situation where you've got a push and pull with the board who might side with the union saying, no, we don't think you have a zipper clause, you don't have to bargain about this till the end of your contract, therefore you can't make any changes, you can't mandate the vaccine. And you're going to come back and say, well, no, that can't be, because I'm going to be fined by OSHA if I don't do this. Then I'll do this right. So hopefully there will be some common ground that you will be able to sit down, with the union and discuss this once we see and understand what the guidance is. But one thing is for certain is that unless you have a very strong unilateral ability, a strong management rights clause in your collective bargaining agreements, you're going to have to sit down and talk about it, whether it's through regular bargaining or whether it's decision and effects bargaining, because the decision has been made by the federal government. And now you're just bargaining over the effects of it. And that can happen even with a management rights clause. So the management rights clause may allow you to unilaterally come up with the policy or implement the policy that provides for mandatory vaccinations, but the union may also have a right to bargain over the effects of that decision and what it means for their employees. Understand also that that regular bargaining rules apply. You don't have to agree to anything, and if you are at impasse, you can implement what you've put on the table. So that we covered a lot, actually. So that's all I have. That's all I've presented today, that I have prepared today. But if you have any questions, I'll try to answer them as best I can.
Okay, Greg, really outstanding job. We do have a couple questions, and some of these are going to actually go back to the original presentation. How do we determine, here's a question, how do we determine which projects do and do not fall under the federal paid sick leave requirement? Does this strictly apply to federally funded projects? We have one current project where the requirement has been brought to our attention, but we will need to evaluate if this requirement applies to any other current or completed projects. Does that make sense?
If I understand your question, yes. So, and this, it should be in your federal government contract that this applies. So this is part of the FAR now, and it should, if you have a federal government contract that's either covered by Davis-Bacon or service contract, or you're covered by this. You should be covered by this. Now, the law requires that it's in the FAR. If it's not in the FAR, if it's not in your federal government contract, then technically you're off the hook. But I wouldn't suggest that you just ignore it. Rather, I would suggest that you come into compliance as quickly as possible. The difference really is, here's the way I would look at it. There's a couple of exclusions, right? So if your contract is for under $2,000, that's excluded. If your contract is for the provisions of goods or services, and I'll say for example, even though it's if you are installing cabinets in a post office, that's services that's covered by the Service Contract Act. That's going to be covered work. If you are building cabinets that ultimately will go into the post office, that is, furnishing goods is not covered government contract work. So the government can contract with you to build products. Those typically are not covered by the Service Contract Act or the Davis-Bacon, but rather just services in support of actually working on site at a federal government. And there's some gray areas there, I understand, but hopefully that they try to give you the delineation of when you might be doing some type of construction work that isn't covered either under Davis-Bacon or Service Contract Act. There's very few types of services One of the crazy things, for example, that is not covered under either would be if you're somehow ever get in the business of ship repair. Ship repair is neither covered under the Service Contract Act nor Davis-Bacon. It has its own separate thing. So, you know, hopefully that helps you. I mean, if you don't know whether you're covered by Davis-Bacon or Service Contract Act, then you need to contact your contracting officer and figure it out with them, because if you're providing services, you're more than 99% likely you're covered by one of the two if you're doing construction work of any sort.
Okay, I guess you kind of addressed this other question, maybe not 100%, but pretty close. Is there a Davis-Bacon number that makes this in effect from a certain number forward, or just any federal contracts after a certain date? Often we have old Davis-Bacon rules in a new contract. So I think you kind of addressed most of that.
Right. So it's really just the going forward date. So if you know, and the going forward date depends on if you've got a collectively bargained workforce, and if if you had a CBA, you know, you didn't have to start implementing this till, you know, if you had a CBA that hadn't expired, let's say you negotiate a CBA, a 6-year CBA that started in 2015, expired in 2021, right? So that applicable CBA, you would not have had to have made any changes for paid sick leave up until January 1st, 2020, when the act said was the latest date that you could do it. So that may have come into play, but after that date, which is now basically, you should be in compliance with the paid sick leave, whether or not your federal contract has it in there, because this is the compliance date, and in most federal government contracts have been renewed since that time as well.
Excellent. Thank you, Greg, for clarifying that. Do we have any other questions for Greg while he's here? I think that pretty much covers it, Greg. Yeah, I think that pretty much covers it. So really appreciate your help, Greg. If there is a very unique situation where a contractor is really troubled by and doesn't really know how to address it, you covered a lot here, but if it's a very specific situation, what's a way that they can reach you? Sure.
You know, they can reach me. Where do I have my I didn't put my contact information here, but I can, you know, they can always call my cell phone. I'll give you that number right now. It's 703-283-0030, or here are my work number. That's 202-230-5393. They can also email me, and that let me see if I can't put that email address up here, but basically it's my first name followed by my last name at fagerydrinker.com. So gregory.ossi@fagerydrinker.com, which is quite a handful. Maybe I can put it in the chat here. I'll just put it right here so you can see my email.
Yep.
So that's my email. You can email me, call me on my cell phone, text me on my cell phone. You know what? Yeah, I try to make myself pretty available, so hopefully I can help you out.
Thank you, Greg, and thank you for everyone for joining. Melissa, anything to share with the team?
No, we're good. I think we're all good. Good. Thank you all so much for coming in, Greg. Thank you again for an excellent presentation. Very informative.
Thank you for giving me the time. Appreciate it. Have a good morning, everyone.
Have a great day.
Thank you.
Thank you.